Any contracts that were signed prior to marriage are what I believe just like separate property would be, meaning if you had acquired an asset prior to marriage, with you being able to prove that it was separate property, would be your separate property. Just like a debt, if one spouse had signed a contract prior to marriage and they were trying to state that the other spouse was actually liable for it, the spouse that is asserting they're not liable could go back and say, actually, you signed that prior to marriage, therefore that is your separate and sole liability and has nothing to do with our community estate.
Agreed. I think the only time we see anything different, and what we always worry sometimes, is people will purchase a home in one person's name prior to marriage. And then at some point during the marriage, they decide to refinance it, and then they'll refinance it into both parties' names. So there is a change there about liability. So do make sure that you pay attention that if you've got something that's in one name only and you do something with it during the marriage, whether you make the determination of whether you intend for it to be both of you or just continue to be separate.
Yeah, that could change the characteristic of whether or not that asset or debt is separate or joint, meaning separate property or community liability.